The plaintiffs are essentially asking the court to force the defendants to go through discovery, pretrial proceedings,
welcome everyone,
summary judgment,
or
just to get to the point where the court finds that the defendants have constitutional rights. That's just a waste of judicial resources and the resources of the parties. Your Honor, with regard to the affirmative defense, nobody cited any cases where the legally permissible element is labeled in an affirmative defense. I certainly haven't seen anything where it's the defendant's burden to prove that if there were to be a trial such that it would be an affirmative defense. Rather, the legally permissible element is really intertwined with the outrageous element. In the seminal case of Metropolitan Life versus McCarson, which is the Florida Supreme Court case that established the cause of action, the court explained how it applied in that case. And it said, the facts as a matter of law are not so outrageous in character and so extreme in degree as to go beyond all.
So just so you guys know, this isn't the actual trial. This is the pre-trial. This is the hearing where the judge would decide whether or not this is going to go to trial or not. If the Petitos have grounds to sue the Laundries.
So, Your Honor, it's not really a defense. It's really part of the outrageousness calculus, that the conduct isn't legally outrageous if there is.
Y'all recognize somebody in there?
Right
Just
that's being asserted.
take a second.
And
y'all see somebody familiar in there? Y'all see somebody familiar? I mean, that hairdo is it's a little it's a little hard to overlook. Yeah, so somebody just has to insert themselves. I wonder if she's going to be outside with a bullhorn acting a fool.
Considering a First Amendment privilege on a motion to dismiss, and held that trial courts, upon motions to dismiss, routinely make decisions as to whether a privilege applies to protect an allegedly defamatory statement. So again, in that context, the court held that on a motion to dismiss, the court can consider a constitutional right of a defendant if that constitutional right is their defense.
Okay, well let's just ask. I know you have identified what you contend is one crime, which is to actively assist Brian evade capture, essentially.
Now, this is
assuming, of course, that and not this is not within the four corners.
Just so you know, this is courtesy of WFLA Now News. We can see the Petito sitting over here. Now, why would BHB be sitting on the Laundrie side? She would be sitting over there so she can make sure that she gets on television.
Accused of, or could potentially be accused of, because before you can invoke a constitutional right to remain silent, there's got to be a crime, right?
Well, Your Honor, there doesn't necessarily have to be a crime. You just have to believe that you may be in jeopardy of a potential investigation.
Well, doesn't the case law talk about it has to be a chain in the causation towards a crime?
Your Honor, I don't disagree with you on that point. What I'm saying, though, is there doesn't have to be a formal investigation. If I left this courtroom and committed a crime and nobody knew about it, I'm not obligated to go confess that crime. Like I can assert my silence for as long as I feel like I need to protect myself.
Well, let me ask you this, because the case law I'm familiar with is in a deposition, the Fifth Amendment would have to be invoked as to each specific question. So, for instance, if the question is, what is your name? You might not have a Fifth Amendment right to not answer that, depending on the context of the alleged crime. So I get back to what is the crime here? And isn't that really something that we need more pleadings to be able to accurately identify so that I have a better standard as to whether or not your Fifth Amendment argument actually is applicable?
I don't think so, Your Honor. I mean, certainly the plaintiffs have alleged criminal conduct, most of which by Brian Laundrie. I'll agree with that. But they do allege that the Laundries, potentially were trying to assist Brian Laundrie in leaving the country, which could be an obstruction, could be something else. Again, we're
isn't
we're
that
not
what
leaving
they
the
did
complaint
though?
when we talk about that? And so in that regard,
Isn't that what they did? Didn't the Laundries basically assist Brian in evading capture? I mean, that's what it came off to me.
is potentially a crime involved. I mean, Your Honor, in Miranda versus Arizona, the Supreme Court held the privilege is fulfilled only when the person is guaranteed the right to remain silent unless he chooses to speak in unfettered exercise of his own free will. So it's the defendant's exercise. It's not something where
This will probably get
the
dismissed.
defendant can maintain his silence only with regard to certain things. If he's not being compelled to answer questions, he doesn't have to speak, period, at all. Again, from Miranda versus Arizona, the privilege has come rightfully to be recognized.
This is why it's a civil case, because it's a moral issue. I don't know how the law works, people. I really don't necessarily. I don't really know how the law works, but it's a moral issue. That's why they're taking this up in civil court. Of course, they can't charge the Laundries for invoking their, Fifth Amendment right. They can't be charged with a crime for that. But at the same time, they could have absolutely helped the Petitos get some sort of closure much faster. I truly believe that. The question is can that be proven in court? That's what I think. I don't know. Just as a layman here, that's what I think. What can they actually prove? Can it even get to a point to where they can prove it? Will a judge even let it go to trial?
Everybody has the right to their private enclave. They don't have to come and affirmatively state everything they know about everything. That's just not the way our society works. It's not the way, it's not how the Constitution works. People are protected.
I want to say Daytona.
They're not.
I'm not sure what city exactly. I know it's somewhere in northern/central Florida, close to where Battery Betty. I'm surprised they even let her in a courtroom. But yeah, this is definitely Florida.
And so that, in my opinion, Your Honor, I don't believe that the Laundries would have an obligation to provide certain information and not provide other information. That they're able.
Sarasota County,
they can
right?
Withhold all information until it's compelled of them. That's or they're provided immunity by the government or whatever the circumstance might be.
Well, let's put a pin in that right now so I can hear from your opponent.
Yes, Your Honor. And Your Honor, for our remaining arguments, we'll just rely upon our papers unless the court has some specific questions that you'd like to address.
Thank you, sir.
I want to be clear about something here. This is WFLA News, who I'm streaming this from, so I don't want them, I'm not trying to watermark my own logo on on this and claim it as my own. But under fair use, I can stream this. It is considered news. So I that's why I'm choosing to stream it. I'm just not trying to take credit for the footage. So the credit goes to WFLA News. Don't sue me.
May it please the court. Your Honor, this case is not simply about the silence of Christopher and Roberta Laundrie, who knew that their son had brutally murdered Gabby Petito. It's not simply about their callous refusal, despite pleas from the Petito family, to speak up about whether or not Gabby was alive and if she wasn't, where her body was located. It's about a course of conduct that they committed from the moment they learned on August 28th of 2021 that their son had brutally murdered Gabby Petito up until the time that her body was found. And as this court has already noted and pointed out, that includes the statement that was made the one time they decided to speak up. They
You
spoke
could tell that dude smells like breath mints and aftershave.
up through their attorney.
Breath mints by Fabergé.
And I'll touch upon the importance of that in a little bit. As the court knows, you're bound to accept as true all of the facts alleged in the four corners of the complaint. And I'd just like to review what some of those allegations are.
Well, let me ask you this, Mr. Riley. And let's lay aside the statement that the attorney made on behalf of the Laundries. What duty did the Laundries have to do anything to help Mr. Petito and Ms. Schmidt?
What?
That's a fair question, Your Honor, and I've struggled with the answer to that particular question. And I guess maybe by answering this, I'm deflecting, but my answer is this. It's about what they did with the information that they have, not just not disclosing what they knew to the Laundries. And by the way, they could have, to the Petito family, excuse me, they could have made an anonymous phone call.
Yeah.
And said where the body was located, and that would have helped this situation tremendously.
Or they could have just simply answered texts like decent people.
They knew starting on August 28th of 2021 that Gabby was dead. They knew where Gabby's body was. They knew that the Petito family was desperately searching for information, but they did things affirmatively. They didn't just remain silent. Brian Laundrie came home in Gabby Petito's van by himself to his family's home. That family, knowing that Gabby was dead, knowing their son had murdered her, knowing where the body was, and in particular, knowing that Joseph Petito and Nicole Schmidt were desperate to learn where their daughter was located, they went on vacation. They assumed and continued
they went on a
their
camping
normal
trip
life as though nothing had happened.
Right.
While this family was suffering, wanting to know what their daughter, where their daughter was. Not only did she not,
and they had a moral obligation because their son was engaged to their daughter. So therefore, that's basically family. They should have at least answered the phone and tried to give some comforting, if not of obviously give information. Like, we need to pull together and make sure that both of our kids turn out safe. Like, the fact that what they did, in my opinion, is they cost Brian Laundrie his life. They facilitated the result of Brian Laundrie taking his own life. And I know it's pronounced laundry. I just like to say Laundrie because fuck them. But they lawyered up. They kept information, whereas they could have just simply had some sort of, they could have, like he said, made an anonymous phone call. An anonymous phone call. Why not? What's the problem there?
Though to legal duty, I hear what you're saying, that these facts might sound bad, but we're not talking about social mores here. We're talking about legal duty.
we're talking.
So let's try to focus in on what duty did the.
I'm glad you asked that, Villanelle. You're saying, is there proof his parents knew their son had killed her and also know where Gabby was? That's what the Breathman dude just said. I don't know. I didn't know that had been proven. I don't think it has yet either. What I think is the goal here is to be able to present the evidence that they do have, if they have any, to a jury. So they're just trying to get the judge to approve this and not dismiss their claims.
Laundries have, what did they owe to Gabby's parents?
Well, let's put in perspective.
They owed, oh my God, really? I mean, I guess the judge has to ask these questions so that it's clear for the record. But I mean, let's be honest. These questions are infuriating because we all know why. And the only reason we're even invested in watching this is because of that.
In perspective, what the relationship was, Your Honor. These people were not strangers.
Right.
These people were Their son was engaged to marry Gabby Petito. Gabby had lived with them for about a year. They had both visited Joseph Petito's home and Nicole Schmidt's home. They were cordial. They had a cordial relationship, a warm and friendly relationship. They knew how much Gabby meant to Joe and to Nicole. Going to the issue of a duty, Your Honor, I struggle with that. Admittedly, it's difficult to say what it is, and that's why I'm saying there was a course of conduct that they did that was outrageous, culminating, in my view, in the statement that was made by their attorney, who, as Your Honor pointed out, is their agent. And what that attorney said in particular is telling. So there's no question that he represented, that he was making that statement on behalf of the Laundries, because he says, it is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming on behalf of the Laundrie family. It is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. That statement was issued with the full knowledge and consent of the Laundries, with the full knowledge on the part of the Laundries that Gabby was not alive and that Gabby's body was located somewhere out west. And instead, they make a statement saying, we hope you find her. We hope you're reunited, giving them false hope that perhaps their daughter is still alive. If that's not outrageous, Your Honor, I don't know what is outrageous.
That's a good point.
So I think when you talk about their affirmative duty to speak up, I struggle with that. But they did speak up. And when they spoke up, they made that very callous, that very terrible statement, giving hope to Joe and
That's a
Nicole
good
that perhaps
point.
Gabby was still alive, with full knowledge that she was not.
Now we
Judge,
need to prove
when
that.
I talk about the course of conduct, I want to talk about some of the cases that I cited in my
He's going to have to
response
prove
the
that.
motion,
I mean,
where the
that's a
court
hell of
found
an
that there was
allegation.
outrageous conduct. And I don't see how any of these cases are by any stretch of the imagination, worse than what happened in this particular case. In the McAlpin versus Sokole case, a patient went to a hospital to have an x-ray done. She put on a hospital gown. She walked into the x-ray room, and the minute she walked into the room, the doctor began berating her in front of other staff because she hadn't paid another doctor's bill. He told her he wasn't going to treat her, and he told her that he was going to call security and have her removed from the hospital. That, according to the court, was outrageous. In Nims versus Harrison, a teacher, two students of the teacher wrote, published, and circulated a newsletter in which they had an article called Low Life, and they referred to that teacher in offensive language, threatened to kill her, threatened to rape
And another
her,
thing
threatened
is,
to rape her children, and threatened to rape.
another thing here is we have to consider that I don't think that this lawyer would even take this case on. Well, it is really high profile, so there's that factor to consider, but most of the time a lawyer won't even take these cases on if there's like a good chance that it's going to get dismissed. And so I don't think that there's that good of a chance of this getting dismissed. He seems to be pretty knowledgeable as far as past cases that could apply to the same things here. So we'll see, man. We'll see.
Their cousins. Outrageous. Ford Motor Credit Company versus Sheehan. Collection agent is unable to locate the debtor, contacts the debtor's mother, tells the debtor's mother that she's from a hospital out in California. She's trying to locate the debtor because two of the debtor's children have been in a serious car accident, and she wants to find the debtor so that she can let him know about this accident. The son speaks to the mother later that day. Here's the story from the mother. Spends the next 7 hours calling hospitals and police departments out in California, only to find out that this story was false. That was outrageous. The Dependable Life Insurance Company versus Harris case was talked about previously. In Liberty Mutual versus Stedman, the company delayed authorizing a lung transplant, even though a judge of compensation claims had already ordered that they pay for the lung transplant. The carrier knew she would die without the lung transplant, so hoping the problem would go away, they denied payment in an effort to intentionally induce stress on her part to speed up her demise. The court said, under the totality of the circumstances, it's outrageous. Williams versus Mineola, and it's these two last cases that I'm going to cite the court to that I think are most instructive here. In Williams versus Mineola, police officers attended the autopsy of a teenage boy who had been murdered or committed suicide, and they were there with a videotape, a video camera.
I mean, that's
and a
what I don't
camera to record it
understand.
because of the suspicion that a crime may have been committed.
Why didn't they contact authorities when Brian went missing in the marsh? Why didn't they do that? They could have saved his life. Like, it stands to reason that if you're accusing them of hiding him and you're accusing them of knowing that Gabby was dead prior to her being discovered, knowing that Brian did it, if you're accusing them of this, it stands to reason that they could have saved his life, that they facilitated in his suicide.
They took that video, they took those photos, and they took them to a party. And at the party, they shared them with other persons, including other police officers from surrounding jurisdictions. And they laughed and they joked about what was in those photographs. The court found that to be outrageous. And here's what the court said. As for what is outrageous or reckless or what is not, we emphasize that our society, as reflected, for example, in decisions of the courts of Florida cited earlier in this opinion, shows a particular solicitude for the emotional vulnerability of survivors regarding improper behavior toward the dead body of a loved one, and the special deference paid by courts to families' feelings where rights involving dead bodies are concerned is central to our decision. This area is unique, and once it has entered, behavior which in other circumstances might be merely insulting, frivolous, or careless becomes indecent, outrageous, and intolerable. One obvious reason is that the bereaved are already suffering psychic trauma because of the loss of the loved one, and are especially sensitized to any disrespect or indignity directed at the deceased body or a representation of it. The potential for severe emotional distress is enormously increased in that situation. All of this is well known to the ordinary person, and so a level of carelessness or callousness, which might not be considered tortious in other situations, can show outrageousness and recklessness when a dead body or a picture of a dead body is involved.
There's definitely callousness. Definitely
How is a
callousness in those
statement,
actions.
We hope this search is successful. How is that in itself outrageous?
It's a lie. It's said with knowledge that there's no hope of finding her alive because she's dead. It's said with an intention to give false hope to a family that their daughter may be alive. That's outrageous.
I like this lawyer.
This is
I
at
hate
this
lawyers.
particular point in time, they had been begging the Laundries to tell them where their daughter was, and this is the statement that they issued. The one time they chose to speak up, this was the statement that they issued: a lie that gave false hope to Gabby's parents that perhaps she might be alive.
That's callous.
The other case, Your Honor, that I think is instructive is the Thomas versus Hospital Board of Directors case, and I think this one may be even more instructive. In that case, during I believe it was a hip transplant surgery, the decedent died.
Look how sad Gabby's mom is. Well, keep an eye out on Gabby's mom. She's wearing the white blouse behind this attorney here. She's really upset.
She died of cardiac arrest. What she really died, the real reason she died of cardiac arrest is because she was given an overdose of a particular medication during the surgery. And the doctors and the nurses agreed that they would not report the true reason for why she died. They would say that it resulted from complications of surgery. As a result, a complete autopsy was not done. The body was released to the family, and less than a week later, as the decedent's daughter was trying to bury her mother, she received a telephone call from the medical examiner saying, "You need to bring that body back immediately. We have to perform a complete autopsy." Again, the court said that was outrageous.
And think about this.
And what the court said was,
think about this real quick. Think about the fact that these people, with all of the hype that this case had, all of the how public it was, these people, you know, they just want to move on with their lives. They didn't give any indication while Gabby was missing, after Gabby was found, all of the sensationalism that this case drew. They didn't come off in any way, shape, or form like they were clout chasing. They wanted to put information out there on domestic abuse and shine a light on that. But the impression overall that I'm getting from these people is they don't want to be here. But the injustice that Gabby got, I mean, they really got no closure, really. That's not closure. Brian offing himself like a coward, that's not closure. They want justice. People need to be held accountable, in their opinion. The question is, can it be proven that they should be held accountable? Now, according to you guys in the chat so far, 84% of you guys, 85% of you guys think that they should be held accountable. I'm part of that 85%. I personally believe that.
We believe that the appellee's conduct in making false statements, and isn't that what Mr. Bertolino did on behalf of the Laundries here? We believe that the appellee's conduct in making false statements, which led to the interruption of Mildred Thomas's funeral and the return of her body for a second, more thorough autopsy, rises to the level of atrocious and utterly intolerable behavior, which cannot be condoned in a civilized society. As noted in Stedman, when an actor has knowledge that the other person is peculiarly susceptible to emotional distress, and the Laundries knew that because this family publicly said they were distressed trying to find their daughter.
Very much
the
so.
Actor's conduct
Repeatedly
may become heartless, flagrant, and outrageous when the actor proceeds in the face of such knowledge. We believe that in a situation where a person's loved one has died, it would be apparent to anyone that the person would be susceptible to emotional distress, and therefore that the action of providing false information concerning the loved one's cause of death meets the standard for a claim of outrage. In this case, they provided false information, a false impression, knowing that Gabby was dead, that she was still alive and she could be found by the family if they were searching in the right place. So I also think under the restatement of tort section 46, comment F says, the extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is peculiarly susceptible to emotional distress by reason of some physical or mental condition or peculiarity. The conduct may become heartless, flagrant, and outrageous when the action proceeds in the face of such knowledge, where it would not be so if he did not know. And that's basically what the Williams court was saying, and that's what I'm saying in this instance. The Laundries knew of the fragile emotional state of Joseph Petito and Nicole Schmidt at the time that that statement was issued. They knew that she was not alive. They knew that the family was hoping to find her, and they put out a statement as though they were supporting them, saying, we know she was our son's fiance. And we hope that you find that body too, or you find her and the family is reunited, excuse me. That's callous. That's callous, it's shameful, and it's outrageous. And by the way, the only reason that Mr. Bertolino is not a defendant in this action is because he's not a citizen of the state of Florida.
Interesting.
I think there's also support for our position under comment E to the restatement, which says unequal position of the parties in a relationship where one asserts and has the powers to affect the interest of the other may also supply the heightened degree of outrageousness required for a claim of intentional infliction of emotional distress. Here, the defendants clearly had the power to affect the interests of the plaintiff because they could have told them where her body was located, and they chose not to do so.
Man, these are serious allegations. I hope he can prove them, man.
Your Honor,
I hope he can prove them.
I don't think there's any question. There's been nothing raised, at least by counsel in his argument.
Because a lot of us suspected this stuff that he's accusing them of, that the Petitos and Schmitz are accusing the Laundries of. A lot of people suspected this stuff. He is flat out making these accusations right now, and I hope he can prove them.
That the conduct didn't cause severe emotional distress to my clients, to the extent that they would suggest and have suggested, well, they were already distressed anyway. So all we did was increase their harm. I guess it's okay to kick someone when they're down, according to the Laundries.
Wow.
But going back to those two cases that I cited earlier involving dead bodies, the parties were already grieving, and it was the conduct after death that the court found was outrageous and permitted the case to move forward.
Now, remember, in interviews, more than one interview, Mrs. Schmidt, Gabby's mom, said that she had a bad feeling. She just knew that something had happened to her daughter, and she just knew it. Very, very fascinating. She knew that the Laundries were lying.
We have the issue of their conduct was intended to harm, or certainly what they did, they should have known was likely to cause severe emotional distress to my clients. We clearly have an outrageous conduct on their part. I think we have established that the conduct caused more emotional distress. It doesn't have to be the only cause of their distress. If it increases, that's sufficient to recover. And I don't think they're contesting at all that the emotional distress was severe. So I'll move on to the suggestion that the defendants get to raise affirmative defenses at this point in time.
Well, and thank you for doing that, because my question there is, I mean, the rule is that I can address it if it is apparent within the four corners, and effectively you alleged conduct which arguably could be considered criminal on behalf of the defendants. So why can't I consider the Laundrie's constitutional right to remain silent and other constitutional rights within the context of ruling on this motion to dismiss?
Well, Judge, I'm curious to find out what conduct it is that the complaint says the Laundries committed that was potentially criminal. So if the answer is they were harboring a fugitive, there were no charge.
I mean,
outside the record, but to my knowledge, or outside the four corners of the complaint,
that's a crime. If they aided and abetted him and they harbored him, that is a crime. If they knew he committed a crime and they helped hide him and they decided to go on a little vacation because they thought this is going to be the last time we get to hang out with our son, regardless of what your feelings of that personally may be, that's a crime.
But the complaint doesn't allege that there were any charges pending against Brian Laundrie at the time. So they couldn't have been harboring a fugitive. Are they?
I'm not sure the absence of charges is the criteria that we use.
Well, Judge, what this is forcing me to do to address that is to go outside the record, which is not what we're supposed to do, to say he wasn't running. According to everything we know, the police knew where he was. So he wasn't a fugitive, so they weren't harboring a fugitive.
That's a good point.
What were the accessories after the fact? I don't know.
That's interesting. Remember, at one point, the law enforcement were like, yeah, we know exactly where he is. You know? So were they harboring a fugitive or not? Because later on, then they say that they didn't know. So, I mean, is law enforcement in some way, shape, or form responsible for Brian Laundrie taking his own life?
Something they want to confess to? I'm happy to hear it, but I don't know that anywhere within the four corners of the complaint there's a suggestion that the Laundries were under investigation for a crime or that they had committed a crime. So, first of all, I think we shouldn't even be considering this as an affirmative defense.
Yeah, secondly, but they have to be able to prove that.
You can't.
He has to be able to prove that. Mouse for U2 and V. Mouse for U2 and V. Got it. Okay. Clever.
Look at the complaint and determine, was there an investigation into them and what were the crimes? So I don't think the Fifth Amendment applies. If we turn to the First Amendment, I will tell you I strongly disagree with counsel's assertion that it applies in all instances. The defendants rely on Woolley versus Maynard for the proposition that they have a constitutional right to say nothing. But Woolley says that the right of freedom of thought protected by the First Amendment against state action includes both the right to speak freely and the right to refrain from speaking at all. And we're not talking about state action in this case. The defendant says we're asking the court to force the defendants essentially to say something. That's not what we're doing. We're seeking damages for their conduct.
Right.
More importantly, the First Amendment doesn't.
Mr. Riley, though, I want to direct you back to paragraph 30 of your complaint, where you say
You got to understand the judge's point of view here. In theory, since I'm not an attorney, I don't know anything about the law really, but in theory, I would think that the judge is in a very, very awkward position because it's a very slippery slope. By making a judgment here, he could very easily well be criticized for overlooking the First Amendment. I mean, that's a scary thing, man. That's a slippery slope that he's on right there. You know, do these people have the right to remain silent no matter what? You know what I mean? So I just don't know how I personally feel about this. Do I think that they should be charged with a crime? If a crime was committed and it can be proven, absolutely, for sure. Because I do feel that their actions were morally questionable, to say the least. But I think that is what makes it grounds for a civil suit.
that the defendants were keeping the whereabouts of Brian Laundrie secret, and it is believed were making arrangements for him to leave the country. So that's something that the plaintiffs themselves injected into the case. So that's the basis of my question is, now that you've put that fact into the four corners of the complaint, isn't that the basis for me to consider, without having to need a affirmative defense filed, if you will, the constitutional rights of the Laundries?
Judge, what's the crime committed there? What's the crime if they are making efforts to try to remove him from the country?
He's not alleging a
charged with
crime.
anything. He's not a fugitive.
See,
there's not, that itself does not suggest that they were committing a crime. There has to be an underlying basis. If the complaint said there was a warrant out for Brian Laundrie's arrest and the Laundries were moving money around to try to move him out of the country, I agree with you wholeheartedly that you could arguably consider a Fifth Amendment argument in this case. But there's nothing in there to indicate that there was any criminal conduct on the part of the defendant. There's a statement that says they were moving money around to try to get him out of the country. Is that
see, that's a smart move on this lawyer, because this lawyer's saying that applies, the First Amendment, it applies when a crime is involved, but he was not a wanted fugitive. Nobody knew that he had killed Gabby yet. He feels that they knew it, but I mean, so this is what makes it really, really complicated is he doesn't, do they get to hide behind the First Amendment since he was actually technically not a fugitive or a suspect even in a crime that they didn't even know took place? She was just missing. He came home with the van. It looks suspicious, but there was no crime that anybody knew of. Oh man, I hope if I get cut off here, guys, I apologize, but I got to walk a dog or I'm going to get. So I'm just going to let this play and hope for the best.
No, it's not.
Okay.
Going back to the First Amendment issue, Your Honor, it doesn't set forth an all-encompassing right to remain silent. Only where through state action they are being asked to espouse a religious, political, or ideological cause which they do not support do they have that right. And I will cite to you from one of the cases in my brief, my motion, the Overbay case, which says, freedom of speech includes both the right to speak freely and the right to refrain from speaking at all. At its heart, the right to refrain from speaking is concerned for preventing government from compelling individuals to mouth support for views they find objectionable or mandating speech that a speaker would not otherwise make. In other words, the court continued, the right to refrain from speaking limits the government's ability to sanction or override a private individual's preference for not making certain speech. Not all speech, certain speech. So let's look at Overbay.
Mr. Riley, you have 5 minutes left, sir.
Thank you, Your Honor. Are the Laundrie suggesting that we're seeking to compel them to mouth support for a view they find objectionable? Do they find it objectionable to tell a grieving family where their daughter's body is located and that that she's no longer alive? Do they believe that they would have a personal individual preference for not making a statement that they knew where the body was located? That's ludicrous. The First Amendment does not apply in this particular circumstance. We pointed out that they contacted counsel to show a course of conduct and to support our proposition that they knew that Gabby was dead and that they knew where her body was located as of August 28th. They immediately contacted an attorney.
I get back to where's the duty, and certainly there's no legal prohibition on calling a lawyer.
I'm not, Judge, I'm not going there. I'm not suggesting, I'm saying that's support for our position that they knew. That's circumstantial evidence, in my view, that's why it's in the complaint, goes to show that at that point in time they knew. I'm not being critical of them retaining an attorney. I'm not suggesting they shouldn't have. I like the fact that they retained Attorney Bertolini, and Attorney Bertolini said what he said on September 14th of 2021. So we're not saying they shouldn't have hired an attorney. We're not saying hold it against them for hiring an attorney. I'm simply saying they hired one immediately after getting a phone call from their son, who then returned home without Gabby. Circumstantial evidence to show that they knew. That's the only reason that I raised that issue about them hiring a lawyer. Your Honor, unless you have any other questions, I believe I've covered everything I wanted to cover.
Thank you very much.
Thank you.
Mr. Luca, I'll give you 2 minutes for any brief reply, but let's keep it to 2 minutes.
Yes, thank you, Your Honor. Your Honor, one thing I would point you to with regard to that City of Mineola case, Your Honor, there is a second DCA case, Crenshaw versus Sarasota County Public Hospital Board. I think it's cited in both my motion and the plaintiff's brief. And in that case, Your Honor, that case also involved a dead body, a stillborn child. And basically what happened is after the child was born, deceased, somebody within the hospital mutilated the child. It ended up going down a laundry chute. And in that case, Your Honor, importantly, the court noted that obviously if the mother had witnessed all of those terrible things that happened to the child, that might be one thing. But the court noted that the physically injured party should be directly involved in the event causing the original injury. If such a person sees it, hears it, or arrives on the scene while the injured party is still there, then that person is likely involved. And then they go on to say, here, appellant did not allege that she saw the mutilated body or that she was involved.
I love
in the
Joe,
event,
man. The
except
dad.
for the birth of the stillborn child in any way. So, and Your Honor, that Stedman case was cited in Mineola. And in Mineola, the fifth DCA said that to the extent that Stedman conflicts, they're not going to follow Stedman. But Stedman would control here because it is a second DCA case. And lastly, Your Honor, I didn't raise this, get time to raise this initially, but I would point Your Honor to another important case, which is MM versus MPS. It's a third DCA case from 1989, again cited in the papers. And although not perfectly analogous, that case is instructive. Because it involves the parents suing the defendant for something that was done to their daughter. And in that case, the defendant told the parents that he had sexually abused their daughter, but obviously the parents were not present for the abuse. In that case, the court found that the appellants were not present when the alleged mistreatment of their daughter took place and may not claim emotional distress for her injurious or offensive treatment.
What the
Now,
fuck is this guy talking about?
The plaintiffs countered that the disclosure of the treatment of their daughter was what caused their emotional distress. And the court said, after reviewing the law, we are unable to conclude that learning the awful truth from the defendant afforded appellants grounds for recovery for their own distress.
No, it sounds.
And the court said, if courts were to allow relatives.
Sounds to me like this is usual defense, right? When it comes to the defense, what they normally do is they deflect, they create a bunch of smoke and mirrors. The idea here is to create doubt with the judge, so the judge dismisses this and it never goes to trial. But he's basically doing a whole bunch of smoke and mirrors and just putting on a show.
Of tort victims compensation for the distress they suffer when they receive bad news about family members, when there is no attendant intentional or reckless conduct directed toward them, an avalanche of litigation would ensue. Compensation is available for actual harm to the victim. Only in carefully prescribed circumstances is compensation permitted for relatives who suffer emotional distress. It is not lack of compassion, but necessity that restricts relief to the immediate victim. And Your Honor, in this case, I would just submit to Your Honor that allowing a cause of action like this to proceed would create an avalanche of litigation that the tort was never intended to cover. Thank you, Your Honor.
What?
Thank you both
An
for your
avalanche,
arguments. I will do my best to get a written order out within 2 weeks of today. Anything else in this first case before we recess the first case?
No, Your Honor. No, thank you, Your Honor. May I be excused?
Yes, sir.
I don't represent any parties in the second case, so.
That's fine. While he is,
Dude's like, I'm
while
out.
Mr. Luca is cleaning up, is there anybody that's going to be here in the second case, which is Nicole Schmidt as administrator of the estate of Gabrielle Verona Petito versus Barry F. Spivey as curator of the estate of Brian Laundrie, case number 2022 CA.
See, that makes sense. See, I didn't even think about that.
Your Honor.
So there's two separate lawsuits here, obviously, duh, because Mr. Petito and Mrs. Schmidt are divorced. They're no longer a couple. So, but they are both the parents of Gabby Petito and both have a stake in this. So, wow. So the Laundries right now are, they got a lot to deal with.
Patrick Riley on behalf.
I can't say I feel sorry for them.
As personal representative of the estate of Gabrielle Petito.
And has anyone appeared for the respondent?
No one, to my knowledge, has appeared.
What do you
As
mean
Your
you
Honor
can't believe
knows,
she's there?
Attorney
Like, I'm
Spivey-
not going to talk much about her because, you know, I've already gone over as much as, but what do you mean you can't believe she's there? Of course she's there. Of course she's there. She has to insert herself. There's just, come on.
Spivey, there was an order entered at the request of Attorney Spivey that because it was the Laundrie family who filed the objection to the claim that was made against Brian Laundrie's estate, they should defend the action. An order was entered appointing them ad litem to defend the action.
And she's there like her opinion matters to anybody.
I'm giving the Laundries a period of time to respond, although the information that I have is that they are not going to, and that a default will be entered.
Well, Deputy Velez, if you could sound the halls for Barry Spivey as curator.
These dudes don't give a fuck. There's nothing personal between these attorneys or nothing. He's like, yep, good job, buddy. Nice to meet you. Good job.
Okay, thank you. The court deputy advises no response to the sounding of the halls. Okay, well, let's what's your intentions then in this case, Mr. Riley?
Your Honor, I've never had a situation where quite like this. So I don't think I'm obligated to give the Laundries 20 days from the time they were appointed as administrators ad litem to defend the action. But to avoid any future issues, I'm going to give them 20 days, and then I'm going to file for a clerk's default.
Okay. And you requested a jury trial in your complaint, I believe?
I did.
Okay, so we'll then have to have a jury trial.
So I guess he's representing
the
both of
issue.
them.
Yes, Your Honor, we would be prepared to proceed to trial on that matter quickly.
So wait, are the Laundries paying two different attorneys? I don't understand. Like, it would make sense that they would have the same attorney representing them, but two separate cases. This guy's like, okay, for the Schmidt case, can I be excused? I'm out of here. I got other business to attend to. Let me shake dude's hand. Good job. See you later. Seems kind of weird to me.
Well, I mean, it's a little premature relative to no default, but are you looking towards November, December, or what was your trial?
Without my trial calendar here, Your Honor, I'm not certain, but probably more likely sometime in early 2023.
Okay. Well, I mean, hopefully for case managements in the future,
Wow,
bring your
so-
trial calendar.
I apologize.
Yeah.
So we won't be seeing a trial, even if it happens. We won't be seeing a trial till next year. I mean, we're talking like at least 6 months from now. At least.
Well, we'll wait and see whether you obtain a default or if someone appears. Obviously, if someone appears, I want you all to go ahead and do the case management order and get deadlines set. And so that we'll get the case rolling. If you end up having a default, then we can set a trial. I don't think we necessarily need a.
It sounds
another
like he's
case
going to grant it.
management. You know, we've got a November 14th, December 12th, then we'll, in the new year.
Your Honor, I can look at my calendar.
Laced and chains, it's the same defendant, different plaintiffs. Like the plaintiffs are Joey Petito and Mrs. Schmidt.
For now.
Yeah. Well, I mean, I can't set a trial right this second because there's no default.
True. Okay.
But the reality is, because you requested a jury trial, we're going to have to impanel a jury on it, assuming that you're going to proceed with the case. I mean, obviously, if you decide not to proceed with the case, then we don't need to have it. But we'll call a jury, and we'll go from there.
Very well.
It's just, I'm trying to.
Yeah, but there's
figure out-
there's two sides to that coin there. Mouse for you to envy. There's two sides to that coin because these poor people that you're looking at the screen right now have that much longer to wait to get justice for their daughter. And that's if they even get it. So, yeah, the Laundries have to wait and suffer, sure, but so do they. And that's a real shame.
With all the other trials going on here and which judges are going to be here when, just need to start planning these things out.
I hope that doesn't mean what I think it means, but for next year.
I have no idea which judge is going to be here in 2023. That's the chief judge's prerogative.
Understood.
Huh.
So I will not reset a case management if Mr. Spivey or an administrator shows up. I'd ask that you go ahead and do a case management order and send it in, a report. If it is a default, send.
You don't know that
send
yet,
my
Pugs.
judicial assistant
You don't know that.
word that the default has been entered, and a couple of dates on our trial calendar where you're looking for the trial to be had, and then we'll go from there.
Thank you.
If assuming that there is a default, how many days of trial are you anticipating?
Oh, okay. That makes a lot of sense, Rabbit Hop X. That makes a lot of sense.
This list will be short.
I suspect jury selection will take us a little bit of time.
Well, that's why I was saying 1 to 2, because I think I could try the case in a day.
Okay. Anything else in the second case, Mr. Riley,
No, Your Honor, thank you.
No? Okay. With that, we're going to be adjourned for the afternoon. Thank you all very much for being here, and have a good afternoon.
Thank you, Your Honor. You as well.
He doesn't look happy. He does not look happy at how things went.
Breaking news on WFLA Now. Here is JB Buno.
Arguments on both sides on whether the lawsuit filed by Gabby Petito's parents, you see them there, Nicole Schmidt, Joe Petito, will proceed against the parents.
Let's let JB
of
talk
Brian
for a
Laundrie,
minute here.
Not in court today. Our recap, our legal analysis begins now.
Yeah, I'm going to let this play, let this guy talk so he can bring us up to speed a little bit better as far as the legal details here.
YouTube Live. The court feed is now going to break up. And in fact, you just watched it break up. And let me explain why. The court, our equipment now is going to move from inside the courthouse to outside. We have invited attorneys for both sides to speak to our reporter, Allison Henning, outside of the courthouse in Venice, Florida. So we anticipate hearing from Pat Riley, the attorney who you just heard, making the arguments for this to proceed to jury trial next year. He has indicated to me via text message that he does plan on speaking outside the courthouse in the post-hearing interview process.
If Betty's out there with a bullhorn, man, I'm going to shit a Jeep Grand Cherokee. I swear to God.
So we'll, of course, find out. But that's the reason why this feed is frozen. They're moving the equipment from inside the courthouse to outside the courthouse. What you really need to know is that we're, of course, going to stay here
I hope so
live
too,
on
Heels in the
WFLA
air.
Now to provide you with legal analysis.
I love
Peter Tragos, lawyer you know, is going to be hopping back on the Zoom
I love hearing lawyers talk about this stuff because I don't know what the hell I'm talking about.
call here in just a moment to provide his expertise. But let's just kind of go over what has transpired. There was a lot of legal minutia, if you will, that I think that some people were perhaps a bit confused by. A lot of this came down to comparative sort of analysis of other cases that were presented. You might have heard other cases brought forth on both sides because of establishing precedent for what is being argued here in this case. Oh, just like that. Our crew is very fast. So we're now live outside of the courthouse, anticipating comments here from Pat Riley. And perhaps we'll hear from Matthew Luca as well. So what we're going to do is we're going to pay attention to this feed. You can see that reporters for various stations here in the Tampa Bay area have set up a makeshift podium, and we expect to hear from the attorneys, or perhaps, well, I don't know if we're going to get Matthew Luca. We're probably going to get Pat Riley. And whether or not the Petito and Schmidt family will speak, that is really completely and totally up to them. But we'll stay here with this live on this podium shot and continue to talk with you as we wait for Peter Tragos to come back in for his legal analysis, his take on what happened. I think that JB. A lot of what you heard in arguing for the motion to dismiss from Matthew Luke, I think a lot of that was legal semantics. There wasn't much for people to really grapple onto as far as the case as we look here live. Let's go live now to Pat Riley coming outside of the courthouse. There you see Nicole Schmidt, her husband, Jim Schmidt. That's Gabby Petito's stepfather. You also see Joe Petito holding hands there with Tara Petito, Gabby Petito's stepmom. So let's see. I believe Pat Riley is going to come on over. Let's listen in.
Good afternoon, everyone. On behalf of Joseph Petito and Nicole Schmidt, we just want to express our thank you to Judge Carroll for the time he gave us today on the motion. We appreciate the time it's going to take him to make his decision, and we have no doubt that he will make the correct decision. The family will not be taking any questions, but I'll do my best to answer a few questions if you'd like.
How do you think the court hearing went today?
I was very satisfied and pleased with the question the judge asked, in particular
about the statement that Mr. Mr. Bertolino made on behalf of the Laundrie family, because that says a lot. The fact that they knew she was deceased, they knew where her body was located, and they had the audacity
Wow.
to express a hope that she would be reunited with her family.
How is the family holding up through all this?
As best I can tell, they're handling it as best they can. If you saw, there were some tears earlier today when we came in here, and I expect there will likely be some more tears.
I know that the family isn't taking anything, but I noticed that Paul was holding on to her necklace. Are you able to share what that, if there's a meaning behind it?
It's Gabby's ashes.
Wow. Wow. That's powerful, man. Very, very
Sorry?
sad.
And the card.
Oh, it's a mass card. It's a drawing or a piece of art that someone from Australia, I believe, created utilizing a picture of Gabby. And on the back of it is a prayer that Jim wrote.
The defense alleged that they had a Fifth Amendment right, even though there was no criminal
Okay.
allegation. How do you feel about that? I heard you arguing about that.
I'm going to pause this because I got to address Heels in the Air's comment here because I very much value her opinions and make sure to sub to her. I'm sure she's going to have more fun BHB stuff. But Heels in the Air saying, I don't know how I feel. Laundrie's punishment, losing a child, seems harsh enough. In theory, yes. But one could also argue that their actions or lack thereof could have saved Brian's life. By keeping quiet, they could have, by keeping quiet, one could argue that they contributed to his demise. So I don't know how I feel. I feel like they could have saved his life. Personally, that's my personal opinion. You're free to have your own personal opinions. But based on when I was following this case as it was going on, I got the impression that they could have absolutely saved Brian's life. And instead, they seemed to respect his wishes to commit suicide. All of the actions seemed to go in that route. I'm not sure if that's actually the case. I don't have any evidence of that other than the circumstantial evidence that I witnessed in a real time following this case. So we'll see. I don't know, but I see what you're saying. I'm going to agree with you when you say I don't know how to feel. I feel like they could have saved his life. My son's life is in danger. I think that he's planning on doing something very foolish and something very emotional. And the right thing to do is to disclose his location to you. Is the route that I feel in theory they should have gone with. But we don't know the exact circumstances of the situation that took place at the time. So I'm not going to go ahead and say that that is absolutely the case because I don't know. It's just a theory.
Well, there has to be an investigation or a crime before the Fifth Amendment right applies. I don't know. And I'm waiting for the day for the Laundries to tell us what crimes they committed. Hopefully they'll do that someday, but I don't know what crimes they are asserting were committed. We did allege that they were trying to move some money around and get Brian out of the country, but there was no arrest warrant out for Brian. He wasn't a fugitive. From a criminal law perspective, I don't think that there was anything inappropriate about what they were doing at that point.
Was it upsetting not to see the Laundrie family present today?
I think for the Petito family, it was a relief.
Yes. If you have to ask me that same question, Kelsey 206, to answer that, I'm going to go ahead and agree with you. I would have turned my child in, but under those circumstances where I believe that turning him in would have saved his life, considering the fact that he's gone, it's easy for me to say, yes, I would have turned him in, but I understand the dilemma too. You know, I feel like I would do everything I can to protect my kid, but at the same time, maybe turning him in is the best way to protect him.
But I would like to have had them be in the courtroom and face the people that they caused harm to.
How confident are you this will go in the favor?
Well, as I said, I like the questions the judge was asking opposing counsel about the statement that Mr. Bertolino made. If someone doesn't find his statements, knowing all the facts that were known to the Laundries at that time, if somebody doesn't find that offensive and outrageous, I don't know what's outrageous.
Interesting. Like he's really hanging on to that lawyer saying what he said.
Judges typically take cases under advisement when there's a lot of research and a lot of cases cited, and so I'm not surprised by that at all. I'm surprised it's only 2 weeks. All right, thank you, everyone.
Attorney Pat Riley speaking outside the courthouse in Venice, Florida.
I can't believe that dude's name is Pat Riley. He even looks like a basketball
Petito's
coach.
Parents and step-parents walking away, hopeful that the decision that is returned in 2 weeks' time is one that will precede the trial.
I agree with you, Heels in
and
the
is
air.
against the Laundrie's attempts to dismiss the lawsuit that they filed earlier this year. JB here, back with you live, everybody on WFLA Now. If I was just making sure that I was hearing that correctly, Pat Riley saying that that was Gabby's ashes that were there today at the, just kill some of that audio, at the courthouse, inside the courtroom. You also saw the prayer card there as well. I know that there are so many people, and I'm looking here now at the YouTube live comment section. Claudia, Marie, Josie, Lori, Sean B., a lot of folks joining us. People who have been saying justice for Gabby, justice for Gabby. So I saw the comment section light up when Pat Riley said that in this post pre-trial press conference.
All right, Jeff Goldblum. And I mean that as a compliment. I like JB. I'm not trying to lie. I like JB. I like JB. I like Brian Enton. I like the coverage that these guys had for this case. She had her ashes hanging around her neck as a you know, like a necklace type situation. You don't know that. I mean, come on. You don't know that. That's a lot. I'm not saying all that. I'm saying they knew where he was, and they could have saved his life. That's my theory. That's what I think. And I don't even know that. You know what I mean? I'm just saying, but I mean, it's a little it's quite a stretch further to say that they were actually planning on getting him out of the country too. Right, a little memorial locket, right, Safari Dream. Yeah, Pugs, that's also a good point. I mean, he was not a fugitive. He wasn't a fugitive. They could have, like, he could have just walked right through a gate with a passport and been like, yeah, I'm taking off. He could have absolutely done that. He was not wanted in connection to Gabby Petito's disappearance. They didn't even know that she had been deceased. That's a good question too. I think we're going to find all that out during trial, but remember that's that's not going to happen for a while. So hopefully before then I'll be going over the Letitia Stock trial. Hopefully. I mean, she's done such a crazy job at wasting the court's time and putting it off and playing with the judge. But yeah, expect at the earliest January 2023. At the earliest. Is everybody having a good week so far? What's today? Today's Wednesday, huh? I did see that, Heels, but like I said, I'm not going back into that stuff. Like I said, I'll be in chats and I'll comment on your videos and all that stuff, but I'm steering away from talking about those idiots on this channel. There's plenty of you guys doing that already right now, and so I meant what I said. I just want to really get away from the toxicity of the Summer Wells circus that it's become. And it really bothers me to call it that, but it's just what that is now. It's not even a missing child case anymore, to the point to where, it's been over a year and law enforcement has said that they don't have any leads. Very little clues, if any, is what they said in that press conference. And they blame these social media creators. So, and I hold Dolly accountable for that. I hold BHB accountable for that. I hold Chris McDonough accountable for that. MGL, JLR. I hold all of those channels, all of them, Ziggy, all of them. I hold them all accountable. I mean, dude, we're talking about somebody who came here to Tennessee and posted on a live or whatever it was when she found animal bones and tried to pass them off as if they were Summers, which is still disgusting as hell to me. I don't understand. I don't understand how that's being overlooked by anyone. Maybe I'll talk about R. Kelly too. I need to educate myself a little bit more on whatever's going on with R. Kelly. Oh, that was Ziggy laced in chains. Yeah, she totally did that. And then attended a party with door prizes here in Tennessee and called it a vigil. Yep, the lab too. I hold him accountable as well. What's his name? Josh. Then there's old Dougie. No thinks investigates, another shitbag channel. Just as responsible. Wow, really? Right. But we should all be getting along. Right? We should all be getting along as a community and put our differences aside. Even though this kind of shit takes place, and this is the kind of shit that law enforcement was talking about, that the TBI addressed directly in their press conference and their most recent press conference and press conferences that took place beforehand, and not to mention the very first press conference where they asked people not to do it because it may have this result. Yet nobody listened. Nobody listened. So, I mean, but we should all be pulling together as a community and getting along is what we should be doing, right? Yeah. No. No. I don't even want to be associated with your community any more than I already have been. More than I ever have already involved myself. I just don't want anything to do with any of you people anymore. Anybody still tagging this child's name without coming up, without sharing any solid evidence, because there is none, should be ashamed of themselves and should be holding themselves accountable for having part in making law enforcement's job in finding Summer more difficult. I don't care if he once wore a badge. Don't care. Yeah, and then then you got this other dude who gets who live streams himself, inserts himself in this case, and just makes a complete joke of himself getting arrested for meth, and then live streaming himself getting tased. It's like an episode of fucking, like, it was like a what do you call it? Those crazy ass videos on YouTube. I mean, it's just, yeah, like the fact that people can't see this. Like, I don't care what you're, I don't care if you're tagging that child's name in your videos. What you're doing is you're exploiting her. Now there's just this really, really fine, if not vague, invisible line now between putting her name out there and getting the word out, because she is an active missing child. This is an active missing child case. This is an investigation that is open because this child is missing and there are no answers as to where she is or what happened to her. There are no definitive answers. And it's gotten to the point to where I feel weird every time her name comes out of my mouth because of what it's become, what this case has become. It's no longer a missing little girl. It's just a bunch of crazy ass fucking people acting crazy towards each other. It's like a nightmare. If I'm this little girl and I can see what's going on and I'm counting on people to help me, it's a nightmare. It's an ongoing nightmare. If her parents had nothing to do with anything that happened to her, they are living a nightmare. Yeah, there's plenty of there's plenty of missing persons cases. I don't even want to take them on anymore. Like, that's what this case did to me. I just don't even. I know that I should persevere and just push through because I'm passionate about it, and but that's what this has done. I'm too scared that I might do more damage than good, even inadvertently. Because every single one of these creators, if you put them on a lie detector test, except for maybe MGL, but if you put them on a lie detector test and ask them, do you think that you're actually helping Summer's case? They're going to say yes, and they're going to fucking pass. It's going to come off as the truth because they honestly believe that shit. Now, Chris McDonough, no. I think if he says yes, that needle's going to go, chick, 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 it's going to go crazy. I think he knows exactly what he's doing. I think he knows exactly how exploitive he's being towards this missing child. I think he's perfectly aware of it. Yeah, no, I don't think that Chris McDonough believes that he's doing good. He's too educated in law enforcement to know that he's not. He knows too much. He's too well educated. Johnny Cuddy, I'm with you. But especially if I believed that he was capable of hurting himself, and I don't believe that his parents were not aware of that. I think there was absolutely that risk, especially if everyone in every comment section on every live stream, every video, everything was saying, I bet you anything that he's going to try and off himself. I said it. Dad Challenge Podcast said it. Yeah, I mean, they had to have known. Sure. You to tell me a little soy boy like that never made threats. You know what I mean? If you don't let me go out this Friday, I'm going to kill myself. If you don't give me money, I'm going to kill myself. Totally believe that. And if there's even a hint, if someone asks you, because I guarantee you that law enforcement at some point asked him that question, do you think that he is capable of hurting himself? If they answered no, well, I think they were lying. Blue Moon, that's the whole point. Okay? The whole point with the fact that, I mean, there's nothing to believe because there's no facts to base any sound theories on. That's the whole point. That's what these people don't understand. There's literally no facts, solidified facts, to base any theories that are floating around on YouTube on. None. And then what was Chris McDonough's like? What was his weasel answer when I called him out for exploiting Summer and using his badge as a selling point to do it? What was his answer? Oh, well, you didn't hear Dawn admit to essaying his younger sister? Well, yeah, I did, but I also heard him admit that he was a child when he did it. It doesn't justify it. Doesn't mean that it wasn't wrong. It was obviously wrong. But as a child, you're not totally responsible for your actions, are you? And he could have just denied it. He could have just denied it. Well, why didn't he just deny it? There's no way to prove it. He could have just said, no, it never happened. It's crazy. Never happened. I don't know what you're talking about. So does that make him look more guilty to me? No, not necessarily. Does it make me look more side-eyed at him? Absolutely. Absolutely, without a doubt. But if he was a child when it took place, well, you know, I mean, I agree with you, B. Fergs. I absolutely agree with you. Let me see what I got here. Yeah, so 90% of you, I'm going to close the poll. 90% of you guys would turn your child in if they were an adult and in that same situation. And I think that's easier said than done too. You know what I mean? Just to be fair, I think that's easier said than done. Because I wouldn't just be like, dude, you know, that's it. It's a no-brainer. I would really, really think about it first. Okay, Kit Brinch, but that's so 5 to, what exact age was that? That's broad. You know what I'm saying? I'm like, I promise you, I'm not trying to defend this dude at all. Like, that shit is not okay. But does it make him more likely to have done something to Summer? Necessarily? That's what I'm saying. I mean, if I'm a juror in a courtroom, it's going to take more than that to convince me that he did something to Summer. It's going to take more than that. I'm not saying that I would be convinced that he didn't do something. I'm saying you're going to have to bring more than that to me before I make a judgment call on this dude's character, whether or not he is a murderer of his own child. Well, it's tough. That's why I created the poll, Pugs. You know what I mean? It's just this way, instead of saying people type a 1, this way you could vote and you're anonymous and nobody can judge you based on what you voted on. Because it's a difficult question. I mean, that's something that you have to think about. Like, I mean, we're supposed to be the most loyal to our own children, if anybody, right? Well, that's an interesting fact. If that's a fact, that's interesting. So, I mean, I'm not here to. That's my point. My overall point on all this is I'm not here, and I don't think anybody should be because they don't have the right to. I'm not here to pass judgment on how people live their lives, how they think nowadays compared to what mistakes they have made in the past. I want to know if there's evidence that dictates that somebody had something to do with Summer's disappearance. That's it. That's it. And if there's no evidence to base a theory on, well, then it's irresponsible to spin those theories. That's my point. That's all I'm saying. And a lot of channels are doing that. Yeah, I don't even want to have to think about a decision like that. I don't even want to have to think about a decision like that. That's insane. Yes. Somebody sent me that and I was like, what? Somebody sent me, they were like, there she is, just looking as blank as ever. They're just making sure that she's in camera shot. I wonder that too, B Fergs, because I'm of the belief, based on the circumstantial evidence that we watched take place in real time while following that case closely, I feel that by turning him in, they could have saved his life. Like, let's just for a second dismiss the morality issue of whether or not they should have help bring some closure to the Petitos and the Schmitz, right? Let's just for a second just dismiss that. If I'm a parent and I'm in that situation and my kid is in that situation, in theory, I'm going to turn my kid in to make sure that they have a chance of a better chance of being alive. Because that's the thing, is if once he's become a fugitive, then guess what? You know, they're on a manhunt for this guy and they got guns drawn and he's got a gun. You know what I mean? And if they confront him in a forced situation, well, then shots get, you know, fired and then people get shot, you know? Whereas if you encourage this person to peacefully walk into a police station and turn themselves in with their hands up, you know, and say, I'm willing to cooperate with you guys on everything, then, you know, there's a lot less likely chance of him being hurt by the police or hurting himself. I don't even think they were thinking about that, B Fergs. I don't think that they cared. That's a whole nother conversation. What I'm saying is they were so wrapped up in, okay, well, our son, we're going to hire a lawyer. And then with their lawyer, I feel like they acted on what their lawyer's advice was. I think their lawyer is a friend of the family. And I think that lawyer gave them advice and not very sound advice. And they acted on their lawyer's advice. That's what I think happened. Instead of simply being parents and being like, hey, okay, well, okay, I get that it's in the best interest of my kid to hire this attorney, but at the same time, you know, common sense dictates that I you know, he could get shot. And the situation could be a hell of a lot worse than it needs to be. Right. See, platform boots, I'm with you on that. Like, I mean, if I just hired an attorney and I just dropped God knows how much money on a retainer for an attorney, what are you paying an attorney for? You're paying an attorney to give you advice, right? It is economically not viable to not follow the advice of your attorney if you're paying them such an obscene amount of money, which is what lawyers charge. So I would have to assume that them dropping all the money that they did on their attorney, that they're following their attorney's advice to a T the entire time. That's what common sense dictates to me. Why would they waste all that money on an attorney if they're not going to follow their attorney's advice? That makes no sense. Yeah, but you don't know that either. Be fair, you're saying there's a lot the Laundries did to interfere in their son's capture that we don't even know about yet. Well, I mean, the fact that you don't even know about it yet, how do you know that it even happened? We don't know. But hopefully we're going to see the Petitos and the Schmidt's attorney prove this in a court of law. Hopefully. Because he's basically making those accusations. He is straight up making those accusations. And I don't think an attorney is going to make those kind of accusations. A plaintiff is going to make those kind of accusations unless they feel confident that they can prove those accusations. So wow. Well, right, Jacob, that's true. But what I'm saying is we have to assume the smart way to go is to assume that they were following their attorney's advice, because why would you pay an attorney the amount that an attorney charges if you're not going to follow their advice? That's exactly what you're paying them for, is to give you advice and tell you how to handle a situation in a legal, when you're in a legal bind. Okay. I got you. I understand. Oh, yeah. You guys can hear my air conditioner? Yeah. It rattles. Sorry about that. Yeah, just, like I said, these renovations, man, I'm waiting on stuff to get here. I ordered one thing from some company and they made me really mad because they haven't even given me an ETA on it. It's just like, dude, come on, man. And when they answer my emails, it's just dodging the question. Like, just give me an ETA on when I can expect this. I have things that are waiting on this. And they're just like, we appreciate your patience. We'll get that out to you ASAP. No, I need a time frame. I need a guarantee. Otherwise, just refund my money. I'll go through a different vendor. I'll get the same thing through a different vendor. You know what I mean? But it's one of those independent people. I like to give people like that my money as long as they know how to treat their customers. But these people don't know how to treat their customers. I'm really upset about it. And I'm really close to just blasting them all over my YouTube channel. It's not even that serious. Like, I'm done with most of it. I just need like a couple of little couple of little things that kind of tie the background together a little bit. And I'm not even gonna I'm not even gonna like wait till I have everything that I'm waiting on. Just this one thing, and then I'll, But oh yeah, as far as weather goes, let me see how. Oh yeah, there's definitely ghosts in here. There's definitely ghosts. Yeah, it's 97 degrees right now where I live, dude. It's literally 97 degrees where I live right now. If I didn't have an AC, I'd be dying. Rainbow 3, as soon as that piece that I'm referring to comes in, that's the plan. And we're going to get started with some new content too, that I'm quite sure you guys are going to have some opinions about. But I'm not going to give anything away just yet. Dude, Jacob, it would feel like it if I didn't have this AC. When I first moved in, we just moved here, so like I'm in my bedroom right now, but I have a space in the basement where I'm renovating to do live streams out of. And when I first got here, this room, because this house is 102 years old, people. So this entire top floor, there are no air conditioning vents in the top floor, right? That's where all the bedrooms are, right? So no air conditioning vents. It's an old house. There's even like electrical sockets that are like super old. You're just like, dude, they don't even make plugs for that anymore. Like doorknobs that are like the oldest thing you've ever seen in your life. And like, yeah, I there's no air conditioning vents. And then I finally got an air conditioning unit, like one of those ones you stick in the window. I got one for my bedroom, and that's what you're hearing in the background, unfortunately. But y'all can kiss my ass because without this thing, I would be dying. Like before I installed this thing, I was just drenched in sweat all the time. It was awful. Awful. I was taking cold showers just to like not die. Yeah, mine is set to 70 degrees, so it doesn't have to work too hard. Wow. 100 degrees in Toronto? It's crazy. That's crazy. Yeah, definitely stay hydrated, people. You definitely want to stay hydrated. Yeah, it's just going to get hotter, dude. Like, it's just the end of June. Like, we're not even in July yet, much less August, people. Like, dude, if you live in Florida or the Bible Belt, like I do, like I live in the Bible Belt. Like, I straight up live in the Bible Belt. Like, where I live, okay, where I live, there's literally like 5 churches to every one place to eat within a mile radius. That's not even an exaggeration. So like, and it's just going to get hotter. It's just going to get even hotter, dude. Do I think BHB should go to Luce and Montello to demand that Dylan Rounds get found. I think they know how to handle her type there. I don't think she should be demanding anything. I think she should just find a hole to crawl in and stay there and quit interfering with investigations. That's what I think she should be doing. I don't think she should be. Yeah, I think she should find something productive to do with her time instead of clout chasing and interfering and obstructing investigations, active investigations. That's what I think she should be doing. I would say she should find a man, but we all know how that turned out 42 times. So I don't know. I don't know what she should be doing with herself. I know what she shouldn't be doing with herself. I mean, I'm not going to sit here and say that I'd like to see her get tased, but I'm going to be honest. If she was doing what she does and I heard a cop warn her not to do what she's doing or they're going to tase her and then she got tased, I wouldn't feel bad. I would. Is that messed up? Is it messed up that like, if she like legit had a reason to get tased and then got tased, would I giggle a little bit? Probably. I mean, probably. I'm not even trying to lie. Like, considering all of the horrible shit that she's done that we watched her do because she shot footage of it and put it out there as content, right? Would it be so bad? You know, it's a non-lethal thing. You know what I mean? It's just, you know, here, have a little jolt to wake you up. Right? Here's just a little, you know what I mean? Like just a little, you know, hey, I told you to knock that shit off. Just a little, you know, I'm not saying I wish it upon her. I'm not. I'm just saying that I wouldn't be like, poor Betty, if it happened. You know what I mean? I don't think I would be. I'd be like, you know, you had that shit coming, dude. You know, I wasn't happy when Critical Gay got her channel taken down. But I also was like, you know what? What'd you think was going to happen? What'd you think was going to happen? One of these days, she's going to get arrested. One of these days, Battery Betty is going to get arrested for the 43rd time. And my attitude will 90% likelihood be, well, shit. Surprised it took this long. I mean, yeah, like I felt bad when I saw Ernie kind of, because I felt like he was confused. You know, I got the vibe that he just was confused. He didn't know what he was doing. He didn't know how to handle the situation. Like, and they tased his ass to get him to stand still. You know what I mean? And I felt kind of bad. Dude, when you hear that crackle, when somebody's getting tased, that shit is not, it's not a comforting sound. I feel like for certain people, it might feel comforting. You know what I mean? Like if somebody's yelling through a bullhorn, let's just hypothetically say somebody is yelling and screaming through a bullhorn, going, you can't stop my First Amendment right to blah, 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 blah. But ma'am, there's a law that's been put into place, basically a Karen law, and you can't be out here Karening. You know, you can't be out here being a Karen the way that you are, you know, and if you don't stop, I have the legal obligation. I have a legal right to tase you. And if you don't, I don't want to tase you, but if you don't stop doing what you're doing right now, I'm going to tase you. Under those circumstances, I just kind of like shake my head, just be like, damn, Betty, all you had to do is just comply. Just like you say, other people who end up getting tased or shot should have just complied. Well, you should have just complied, man. I'll tell you who I'd like to see get tased, though, for sure. JLR. I'd like to see JLR's dumbass get tased. I'd like to see JLR just like, guys, it's Jonathan Lee Riches, a.k.a. JLR. I'm out here and the police are trying to tell me what I can and cannot. Ow! I told you, get down. Get down, son. I told you to get down. Dude, that sound effect is not, dude, like, you know that hurts, dude. Like, you can hear it hurt it. Think about that. Like, this thing is just like, you got this thing that's like that pinches your skin. The metal pinches your skin and then sends like hundreds of thousands of volts into your body. Just, that's gotta hurt, man. It's gotta hurt, dude. I feel like JLR has like a few of those coming. Like there's a list. There's an imaginary list somewhere of incidents that merit JLR getting tased. That should be like any cop should have that list and be able to cash in on that. Like that's not how liberty works. You know what I mean? That's not necessarily how liberty works. You can't just you can't just keep a list of shit that you did that merits you getting tased. But I feel like if there's a cop that knows who he is, he has that list in his mind and then just waits for him to just fuck up for a second. You know what I mean? Just and be like, yeah, I remember that James Holmes bullshit that you did. Yeah, I'm gonna have to tase you, dude. Guys, this is Jonathan Lee Riches, aka Jail. Oh shit! I shit my pants. Yeah. I'd love to see that shit. That dude has done so much to merit a tasing, bro. Like, there's no, like, he could be walking down. That's the dude. I'm not going to say the same thing about BHB. I know a lot of people will, but I'm not willing to go that far about her. But JLR, most definitely, like, if someone just randomly ran up to that dude and tased him, I'd laugh. Like, I would just bust out laughing, dude. If somebody just randomly was just like, I know you, asshole. This is for the Sandy Hook victims. Ow! Damn it. I pissed myself. That would bring me pleasure. I'm not even trying to lie. Because it's not like I'm wishing him to get shot or nothing. I'm not saying all that. I'm saying, why can't he just get tased? In a perfect world, that dude is randomly getting tased. Just like that one leader of the white supremacy movement that got like elbowed in the face on camera. Like, I'm not shedding any tears for that guy. You know what I mean? I'm not shedding no kind of tears. I'm like, what did you expect, dude? Talking about Guys, we need to have taser control laws put into place. Okay, not gun control, because that's our Second Amendment, but taser control laws. You can't just let any random asshole who sheds tears for school shooting victims to run around and tase me. Can you imagine that? People just sitting around with a taser and they're like, oh shit, look, dude, it's that dude that never blinks. Bet you I can make him blink. Watch. How much you want to bet I'll make him blink? Now, I'm not, please don't, if you have a taser, don't go out and tase this dude. I'm just saying, if I saw it, I would laugh. I'm not encouraging anyone to actually do this. I want to be very clear about that. All right? Do not tase people unprovoked. Okay? If you own a taser, that's not okay. You can't go around doing that shit. Can't do that. All right? All I'm saying is, as a random spectator, if I just happen to just be scrolling down my feed on YouTube and then I see a headline that says JLR gets tased, I'm clicking on it. I'm clicking on it, and I'm ready to click on it over and over again. I'm like, okay, I'm gonna play this more than once. I'm already sitting down. I'm like, I'm gonna play this more than once. That's all I'm saying. But in no way am I encouraging anyone to go out and tase anybody. Don't do that. All right? Just saying, if I saw it, I would laugh. I feel like, morally speaking, that dude has earned notches on the tasing belt. Just as a dude that's like, just as a YouTube subscriber, dude, just scrolling up. Oh, JLR get tased? Click. Damn these ads. 5, 4, 3, 2, 1. Skip ad. Yes. Ow. I got a turtle head. I'm telling you, I'm just laughing. Like I'm literally picturing the scenario. Guys, this is Jonathan Lee Richards, aka JLR, with his weird tiny little mouth. That dude has the biggest small mouth. Jonathan, aka JLR. Oh shit. Now there's something seriously wrong with that dude. And not even in like a you get dismissed from having to testify or stand trial kind of way. Like just in a this guy sucks because he just refuses to even try to relate to anybody else. Hey, what's going on, y'all? This is Dolly. I'm out here. Oh, shit. Oh, god damn it. I done pissed myself. Guys, I love you. We will do this again very soon, my friend.